Councilmember White or his representative, who will be given an opportunity to make an opening and a closing statement, to call witnesses on the accused's behalf, and to question any witness who might have been called by the chair of the ad hoc committee. The rules do state the accused may be represented by a person of the accused's choice, whether or not the person is an attorney at law, and may have that representative speak or question witnesses on the accused's behalf. A resolution has been filed and it's pending in the council, and as I noted in the December 17th, 2024 memo to Councilmember Trayon White, it is my intention that this will be on the agenda for the February 4th legislative meeting. So I will read from the resolution, and if there's no objection from Councilmember White or his representative, what I'm going to do is read Section 5, which is DC Official Code violations, ask for a response, and then read from Section 6, which is council rules and code of conduct violations, and ask for a response. Thank you. So Section 5, DC Official Code 1-1162.23 prohibits an employee from using his or her official position or title, or personally and substantially participating through decision, approval, disapproval, recommendation, the rendering of advice, investigation, or otherwise, in a judicial or other proceeding, application, request for a ruling or other determination, contract claim, controversy, charge, accusation, arrest, or other particular matter, or attempting to influence the outcome of a particular matter, in a manner that the employee knows is likely to have a direct and predictable effect on the employee's financial interests or the financial interests of a person closely affiliated with the employee. Subsection B, DC Official Code 1-618.01 requires each employee, member of a board or commission, and public official of the district government to at all times maintain a high level of ethical conduct in connection with the performance of official duties, and to refrain from taking, ordering, or participating in any official action which would adversely affect the confidence of the public in the integrity of the district government. Subsection C, Councilmember White's June 26, 2024 and July 17, 2024 meetings with an FBI confidential human source, referred to as CHS-1, where Councilmember White accepted a $15,000 cash payment from CHS-1, discussed plans to meet with district government employees based on CHS-1's payment, discussed other opportunities to help CHS-1 secure further business with district agencies, accepted CHS-1's offer of a 3% kickback of each contract or grant's value that Councilmember White assisted in securing, and discussed potential expansion of his and CH1's enterprise into the mental health care and housing sectors, are consistent with the violation of the statutes that I just read in subsections A and B of this Section 5, as established by the Latham report. Do you admit, Councilmember White or your representative, do you admit or deny these specifications and charges? Can you put your microphone on? It's on.
On behalf of Councilmember Trayon White Sr., we deny the allegations, the specifications and charges.
Thank you. You should identify yourself for the record.
Sure. Thank you very much. My name is Frederick D. Cook, Jr. I'm counsel for Mr. White. I'm a member of the D.C. Bar number 164608.
Richmond, Virginia.
Thank you. And you deny the
and we deny the allegations and specifications and charges.
Let me turn to Section 6, which is Council Rules and Code of Conduct.
The Senate will come to order. The senators will take their seats. Those persons not entitled to the privileges of the floor will please retire to the gallery. Prohibits an employee
from receiving any compensation, salary, or contribution to salary, gratuity, or any other thing of value from any source other than the district government for the employee's performance of official duties.
If you are able, please rise.
Rule A1
We will be led in prayer
provides
this
that no
morning
employee shall
by the
engage in
very
outside employment
Reverend
or private activities that conflicts
Proto-Presbyter
or would
Nicholas
appear to conflict with the fair, impartial,
Buckless
and objective performance of the
of the
employee's official
Saints
duties and
Constantine
responsibilities
and
or with the
Helen
efficient
Greek
operation of the
Orthodox
council.
Cathedral in
Rule
Richmond. Following the
2C1,
prayer, if everyone will
subparagraphs A
please
and
remain
B,
standing,
prohibit
and we
an
will be
employee
led
from representing
in the
another
Pledge of
person,
Allegiance
having a
to the
financial
United
interest,
States of
or
America
providing
by
assistance in
our Senate
prosecuting a
page,
claim against the
Christian
District of Columbia
Fitzgerald
before any
of
regulatory
Hampton.
agency or court of the District of Columbia,
May we
or
bow our
from
heads in
representing
prayer.
another person before any regulatory
Almighty and
agency or
merciful
court of the
Lord,
District of Columbia
we thank
in a
you for
matter
the
in which the
privilege of
District of
serving
Columbia
in
is a
this
party
austere
and has a
body
direct and substantial
to
interest.
represent those who have elected
Rule
us to the position which we are blessed to
3E2
hold.
provides that,
Guide us in our
except as provided
deliberations.
in Rule
Grant us
4,
wisdom,
no employee
understanding,
shall directly or
and the
indirectly
fortitude
demand,
to stand
seek,
up
receive,
for what is
accept,
right
or agree to
and not to
receive or
succumb to
accept anything of
partisan
value personally
intransigence.
or for
Help
any
us to hear
other
and understand
person
the
or
thoughts
entity
expressed
in
by our
return for,
colleagues, and to
1,
be able to come to
any
thoughtful
official act performed
solutions
or to
the
be
many
performed by the
challenges which we
employee,
face.
2, being influenced in the
Allow this to be
performance of
done in
any
a
official
harmonious
act,
manner, so
3,
we can
being
set the
influenced to
example for
commit
others in
or aid
elected
in
and
committing
appointed positions.
or to collude
From
in
our diversity,
or
grant
allow
us unity
any
and
fraud
harmony
or make
so that we may
opportunity for
best
the commission
serve
of any
all
fraud
Virginians.
on the District of
Bless the
Columbia,
esteemed members of this Senate,
or
their
4,
staff,
being
the
induced to
support
do
staff
or
throughout this
omit to
building,
do any
and
act
their
in violation
families
of the
as they
employee's
offer their
official
time and
duty.
talent for the continued progress
Rule
and governance of our
6B,
Commonwealth.
paragraphs
For you
1
are the
and
one who
3
bestows
state
abundant
that an
blessings upon
employee
us,
may not
for which we
knowingly
express
use
our
the
thanksgiving
prestige
and
of office,
gratitude.
use of their position or title or any authority associated with their public office in a matter that could reasonably be construed to imply that the council sanctions or endorses the personal or business activities of another, unless the council has officially sanctioned or endorsed the activities. Paragraph F of this section reads, on 4 separate occasions between June 2024 and August 2024, Councilmember White accepted cash payments from CSH1. The cash payments described in paragraph 1 of this subsection totaled $35,000. Councilmember White knew at the time of accepting these cash payments that CHS1 operated several businesses holding or seeking contracts or grants with the District of Columbia, or that CHS1 had received subcontracts or subgrants from businesses that contracted with the District of Columbia. Councilmember
The
White
clerk will
accepted
call the
those
roll.
cash payments in exchange
All
for
those
agreeing to meet
present,
with and
please
influence
vote
various government
aye.
officials to ensure the contracts of CHS1's
The clerk will close the
organizations
roll.
would be renewed.
You have a quorum,
Councilmember
Madam
White agreed to
President.
accept
Senate Journal for Monday, January
$156,000 in
27,
undisclosed kickbacks and cash
2025.
payments
The
in
senator from
exchange for
Colonial
using his
Heights,
official position
Senator
as a
Sturtevant,
council member
moves that the
to
reading
help
of the journal be
organizations
waived.
obtain
All
or
those in
retain
favor of
contracts or
waiving the
grants with
reading of the
district
journal will
agencies.
record their votes aye. Those opposed,
Councilmember
no. Are the
White
senators ready to vote?
reviewed a ledger with
Have all the
CHS1
senators
that
voted?
outlined profits he
Does any
expected to
senator desire
receive
to
for his
change their
continued
vote?
work, including a 3% cut
The
for
clerk
grant
will
renewals
close
he
the
helped
roll.
secure.
Ayes
Councilmember
36,
White
noes
confirmed that
3.
he had
Ayes 36,
contracted,
noes 3. The reading of
excuse
the
me, that he
journal
had
is waived. The
contacted
clerk will now
government
report
employees to
any
discuss
communications from the
contract
House of
renewal
Delegates.
and
Chair
stated
calls
he
on
discussed contracts
Senator
over with,
Sturtevant.
met with
The question is,
Department
shall
of
the
Youth
reading of the
Rehabilitation
communication from the House
Services
of Delegates be waived? Those in favor will
or
record their votes
DYRS
aye. Those
and
opposed, no. Are
Office
the
of
senators
Neighborhood
ready to
Safety
vote?
Engagement
Have all the
or
senators voted? Does any
ONSE
senator desire to change
officials
their vote?
within days of his multiple meetings with CHS1 in July
Senator Williams
2024,
Graves.
and he asserted to CHS1 that he had held such
The clerk will
meetings
close the roll.
and discussed with those DYRS and
Ayes 36,
ONSE
noes
officials
3.
Ayes
matters
36,
over
noes 3.
which
The reading
the
of the communication
CHS1
from the
had
House
a
of
direct
Delegates
interest.
is waived. The clerk will report
The facts
any
asserted above
communications
are
from
consistent
the
with the
governor.
violation
We do
of the
not have
council
any,
conduct
Madam
rules
President.
described in subsections A through E of this section.
We've arrived at that
to
time in our
section
morning
6
hour,
of the
what we
resolution
call our morning hour,
as
where we
established
will
by
discover
the
who all of you
Latham
beautiful
and
people are.
Watkins report.
And the normal procedure is that your
Mr.
senator
Cook,
will
do you,
rise
on
and
behalf
tell
of
us
your
who you
client,
are. And
admit
please,
or
at that
deny
time,
these
if you hear your
specifications and
name
charges?
or your organization called,
On behalf of
please
Councilmember
rise, and so
Trayon
we'll
White
know.
Senior,
And if you'll hold your applause
he
until
denies
after I've
those
welcomed
charges
you,
and specifications.
then we can applaud you all together.
Thank you, Mr.
And
President.
so I now call on
I will
Senator
turn now
Pekarsky,
to the
Senator
chair
from
of the ad
Western
hoc committee,
Fairfax County.
Kenya
Thank you,
McDuffie.
Madam President. I have an introduction.
The
Thank
senator
you,
has the floor.
Chairman.
It is my honor
Conducting
this
an
morning
investigation
to welcome the very
into a
Reverend
colleague accused of wrongdoing is one of the more
Nicholas
solemn
Bakalis.
duties
He
of a
offered
council member.
us the
But it is appropriate and
invocation
necessary
this
responsibility
morning,
placed on
and
this
he
body by
is
the Home
a,
Rule Act, the council's rules, and most
he has come
importantly,
before,
the
so it's
residents
nice
of the
to
District of
welcome
Columbia.
him again this morning.
We,
Father
not only as
Bakalis was
individuals, but
born
as a
in Norfolk,
collective,
Virginia, to
must
Greek-American
ensure that
parents,
all who
George
serve on
and
this body
Connie
uphold the public trust.
Gretakis Bakalis.
When that trust
And
is
in
broken, we cannot
1996, he was
leave
appointed the
disciplinary
dean
action
of the Saints
to some other body.
Constantine and Helen Greek Orthodox
We must act.
Cathedral,
Pursuant
in
to the
Richmond,
council
Virginia,
rules,
here.
on August
And in
23rd,
addition to his parish
2024,
responsibilities,
Chairman
he
Mendelson
serves as
issued a
regional
memorandum
vicar for
establishing an ad
Southern
hoc committee
Virginia
to
on
investigate
behalf
allegations of
metropolis
misconduct
New Jersey,
that came to
and
light
previously
with the
served
August
as treasurer
18th,
and president
2024
of the
arrest of
Archdiocesan
Councilmember Trayon
Presbyters
White Sr.
Council, as well as
Federal
member
prosecutors
of
have
the
alleged that through a
Archdiocesan
series of
Council.
payments,
He is part
Councilmember
of the
Trayon White Sr.
chaplaincy
took
staff
bribes
at the
from an
University of
individual whose
Richmond
company held a
as
DC
spiritual
contract and
advisor
agreed to
to our
use.
Greek
The arrest took
men
place
this Sunday
at an
with
apartment
my
building
children,
outside of
and I
Councilmember
hope that you
Trayon
will
White's
offer him
ward,
the
leading
very
to
warm
questions of whether
welcome
he
of the Senate.
continued to meet
Well,
the
now,
residency
Reverend
requirements to serve as a
Bakalis,
ward
now I know
councilmember
how
under
to
the Home Rule Act.
pronounce it well, and with a name like mine,
Pursuant
I'm pretty
to
particular about
proposed
name
resolution
pronunciation. So
25-634,
we thank you for coming.
the ad hoc
as
committee
usual. Thank you
retained
for
Latham
coming.
and Watkins
And
law firm
we're
to
so glad
assist
that
in
you
the
do all
investigation.
that you do in
The
your
approximately
community.
11-week
I hear
investigation included interviews with
sacrifice, and
individuals
everything
believed to have
that the
information
senator
related
has
to the
said.
matters under
Thank you for
investigation
doing that.
and the
Senators,
review
let us give
of
him the warm
potentially
welcome
relevant
of his
documents and
Senate.
other materials. The Latham team conducted interviews with officials from multiple District of Columbia government agencies, including the
Senator
Department of
Jordan,
Youth Rehabilitation
the senator
Services
from
and the
Isle
Office
of
of Neighborhood
Wight.
Safety and Engagement,
Thank you, Madam
and
President.
the
I
Office of
rise
Risk
for an
Management.
introduction.
The senator has
Current
the
and
floor.
former members of
Try this again
Councilmember
from
White's
yesterday.
staff,
In the gallery today,
leaders
we
in the
have
violence
two
intervention
of my fellow
community,
advisory board members from
and other
St.
individuals
Paul's
believed to have
Museum
information
in Lawrenceburg,
related to the
Virginia.
allegations
Bobby Connor and
against
Malcolm
Councilmember
Mitchell would
Trayon
rise.
White. The investigation team
you, gentlemen.
also reviewed relevant documents, including
So a
publicly
little bit of
available
story we had
materials,
yesterday, but I will
records obtained
reiterate.
from DYRS, Office of
Bobby
Neighborhood
Connor
Safety and
serves as the
Engagement,
vice chair
and
of St.
other
Paul's
DC
Museum and Archive,
agencies,
but he's done so much
records
more.
relating
He
to
has put
Councilmember
together,
Trayon White's
the
residency, and thousands of
largest
emails
amount
from
of
the official
historical
accounts of
pieces
Councilmember
from
Trayon
St.
White
Paul's,
and
which
his
is
staff.
one of the
Over the
6
course of the
original
investigation,
HBCUs in
Latham
Virginia,
conducted
and he has
interviews
done
with
such a
almost
great job
24
with making
individuals
sure
and
all is
reviewed
taken care of
approximately
and
20,000
well-preserved.
documents,
Also with us,
amounting
one
to
of
more
our fellow
than
advisory board members,
200,000
Malcolm
pages of
Mitchell,
materials.
which many titles.
This
but
investigation
a New
was
England
thorough
Patriot, a
and
Super Bowl
independent,
champion, and I think
and it
probably
respected
his
the due
most
process rights of
impressive
Councilmember
title
White
now as the CEO
throughout.
of Share the Magic Foundation.
Notably,
where he
the ad hoc
ensures
committee
that he
offered
transforms the lives of our
Councilmember
youth,
Trayon White
with the
3
power of
opportunities to
literacy.
address the committee
Having
before
them
and
both
after
at
the
gallery
Latham
today
report
is
was
incredible,
completed.
but they're doing so
Respecting
much for the community
Councilmember Trayon
of
White's Fifth
Lawrenceville and
Amendment rights, the
especially
committee
Brunswick
did
County
not
and the
seek to
memory of St.
compel his
Paul's.
testimony.
We are so honored to have
The
them
findings of the
here today
investigation
in the
are
Capitol.
fully laid out
And if
in
you
a
have a moment,
report
I
that
hope you
Latham
would give
provided
them a warm
to the
welcome
ad
of
hoc
the
committee
Senate.
and has now been published.
Good afternoon,
The committee
gentlemen.
made
Thank
that
you so
report
very
available
much
to
for
Councilmember
coming, and we
Trayon
heard
White,
a great
again,
deal
and to the
about
public
you
on December
yesterday.
11th,
And
2024,
here you are in
the
person
same day
today,
that the
and,
council looks to in matters
citizenship
such as these
and
is not the same
making sure
standard
that
as in a
you
criminal proceeding.
really better yourself
Proof
and,
beyond a
and
reasonable
then
doubt
bringing
is
others
not
with
required.
you. And thank you for the museum.
Councilmember White
And I've
will
been
have
to
his day
St.
in court
Paul's,
to
and
face the criminal
we do
charges,
hope
and the
that
burden will
she
be on the
thrives again.
prosecutors
Thank you.
to prove that
Senators,
the
let us
allegations
give
beyond a
them the
reasonable
warm
doubt
welcome
in
of
that
their
case.
Senate.
Expulsion is the most severe punitive action, serving as a penalty imposed
Senator Eben,
for
the senator
egregious
from
wrongdoing
Alexandria.
by the council and results in removal
Rise
of
for
the
an
member of the
introduction.
council.
Senator may continue.
For this
Joined
sanction,
today
the
by
council
two
must
members
find
of
by
the
substantial
Alexandria
evidence
School
that
Board,
the council member committed
including
a
the chair, Dr.
violation of
Michelle
law
Reeve,
that amounts
and
to a
Tim
gross failure
Beatty, who's a member
to meet
as
the
well.
highest standards
They're
of
doing an
personal and
excellent job
professional
in dealing
conduct.
with a diverse student population.
The Latham report lays
and
out that the
keeping
firm found
Alexandria safe substantial
schools of
evidence that
cutting edge.
Councilmember
So,
Trayon White
with that, I
Sr.
ask that you accept
violated the
them
law
and
and
welcome
council
to the
rules
Senate.
as it relates to the allegations
There
of
you are.
bribery leveled
Thank you
against
very
him.
much for coming and seeing your
The
Senate in
indictment
action and
alone
letting
could
us
be
know
viewed
what's on
as
your
substantial
minds.
evidence, given that the grand jury of the District of Columbia
Being on the
residents
school
viewed
board is no
the evidence
easy
presented
task.
by
We
the
know
United States
that.
Attorney
And
and
you've
believed
got
that
a
probable
lot
cause
of
existed
work
to
to
charge
do to
Councilmember
help
Trayon
to
White
shape the
with the
minds
bribery
of these
crimes
young
contained
people.
in the
Thank you.
indictment.
Senators, let us give them the
But the
warm
Latham
welcome of
investigation
their
does
Senate.
not simply rely on the indictment and affidavit from the FBI agent. The investigation was able to
Senator
corroborate
Williams-Graves,
allegations
the
through
senator
witness
from Norfolk.
testimony documentary evidence, and surveillance video.
Thank you, Madam
Based on the
President.
facts gathered during the investigation,
Madam President, I
the
rise
investigation
today
found that
for
there is
3
substantial evidence that
introductions.
Councilmember
Senator
Trayon
may
White
continue.
violated
Thank you.
council
Madam
rules
President,
and several provisions of the Code of Official.
And
As I
we
list
have
these, I'm going to
Virginians
use
representing
the
the
shorthand
industries that
of
serve
informant
us,
to refer to
all
the
at one
confidential
time
human
or
source.
another. The Virginia Restaurant, Lodging,
Specifically,
and Travel
substantial evidence
Association.
supports the
And they're in the
conclusion that
gallery. Will they
Councilmember
please
Trayon White
stand?
accepted
They are on Capitol Hill
$35,000 in
today
cash
as
from the
part of their
informant
annual
identified in
Day
the
on the
indictment.
Hill. Veralta,
Knew
as
at the
they are
time of
commonly
accepting
called,
these cash
is the
payments
unified
that the
voice
informant
for
operated
Virginia's
several businesses
restaurants,
holding or seeking
hotels,
contracts or
tourism
grants
authorities,
with the District of Columbia,
campgrounds,
or that he had
hospitality
received
suppliers,
subcontracts or
and
subgrants
attractions.
from
It
businesses
was formed
who
from the
contracted with the
merger
District
of
of Columbia.
several individual
That he
organizations
accepted
in
those cash payments in
1993
exchange for
to
agreeing to
provide
meet
a
with
more
and
central,
influence
potent
various government
voice
officials
for
to
those
ensure
industries.
the
And
contracts
today,
of the
they
informant's
comprise
companies
8
would be
local
renewed.
chapters throughout the
That he reviewed a
Commonwealth.
ledger with the informant that
Tourism is
outlined
one of
profits he
Virginia's
expected to
biggest
receive for
industries,
his continued work,
generating
including a 3%
33.3
cut
billion,
for grant
that's billion
renewals
with a
he
B,
helped secure.
dollars in visitor
That
spending
he
in
confirmed he had
2023.
contacted
Tourism
multiple
in
government
Virginia
employees
directly
to
supports
discuss
over
contract renewal and stated he
321,000
discussed the
jobs
contracts in which
in
the
the
informant had
Commonwealth,
a
and
direct
travelers
interest.
here spent over
That he did in fact
$91
meet with
million per
DRS
day
and
in
one's
2022.
officials within days of his
Veralta's
multiple
members
meetings
are
with the
instrumental
informant
in
in July
providing the services
2024,
and attracting the
and that he
visitors
did in
that
fact discuss
contribute
with
to
those
those
DRS
eye-popping
and one's
numbers.
officials matters over
From
which
running
the
your favorite
informant had a direct
restaurants to
interest.
giving weary travelers a place
I
to
will note that
rest,
while the
to
investigation found
showcasing
substantial
all
evidence
Virginia
that
has to
Councilmember White
offer,
has a
these men
connection
and
to the
women
apartment
and
in
their
Ward
teams
6,
are making it
there's
happen
also
every
substantial
single
evidence
day.
that Councilmember White
Madam
has a
President,
strong
I hope
connection
it will be the
with Ward
pleasure
8.
of this body to
Based on
give
the law, the
them a
investigation could
warm
not conclude
Senate
that there was
welcome.
substantial evidence that Councilmember
Indeed,
Trayon
and
White
from what I've
violated
heard
the
the
Home Rule
senator
Act with
say,
respect
it
to
occurs to me
residency.
that your industry is
Based
really
on
in
the
charge
finding
of
of
the
substantial
first
evidence that
impressions
Councilmember
that
Trayon
people
White
get
violated
of
several provisions
Virginia.
of the DC
Lodging,
Code of Conduct and the council rules that amount to a gross
restaurants,
failure to
how
meet
they
the highest
eat,
standards of
etc.
personal and professional
And
conduct,
so that
the
means
ad
that
hoc
we've got to
committee
make sure we put
unanimously
our best
approved
foot
to
forward,
recommend
and
to
we
the
want to
council
help
the
you
sanction
to
of
do that. I
expulsion
mean,
of
she
Councilmember
did
Trayon
say
White
billion
on
with a
December
B is what you
16,
contribute to our
2024.
economy, and we want to keep it
I
that
submit
way
for today's
and
public hearing
improve it.
record
We
the
want to
ad hoc
make
committee's
Virginia the
committee
best place
report,
to live,
which
work, and
includes the
raise a
Latham
family.
report
And
along
if
with
they
the
come, they'll
29
see that.
exhibits
So
upon which
thank you for what you
Latham
do. Senators, let us give
relied.
them the warm welcome of their Senate.
Finally, I want to reiterate the council's precedent because some have alleged that a sanction of expulsion is inconsistent with
Madam
past council
President,
practice.
the remaining 2 introductions
As I've
are
stated
from
before, in the more than
both
12
my
years that
alma
I've been a
maters,
council member,
TCC and ODU.
there have been 3 ad hoc
Today,
committees.
I am pleased to recognize
chaired
College
2 of
Board
them.
members, staff, and
The first
students
involved
from
an
Tidewater
allegation
Community
that then
College.
Councilmember
They too are in
Marion
the
Berry
gallery.
accepted
Please
gifts from
stand.
prohibited sources. The facts of
Dr.
that
Marcia
case were
Constant
very
is
different.
the 6th president of
Councilmember
Tidewater
Berry
Community
disclosed the
College.
gifts himself
She has been serving as
on his
president
council
since January
financial disclosure
2020.
forms,
Under her
admitted his
capable
wrongdoing,
leadership,
and paid a
the
fine
college
to the
is
Board of Ethics and
experiencing
Government
enrollment
Accountability.
growth in both
But the most
transfer
important
students and
distinction is
workforce
that
training.
the ad hoc committee
More
found
Virginians are
insufficient
getting
evidence
trained,
to conclude
upskilled,
that
and
the gifts
upfit,
involved a
all
quid
leading to
pro
job
quo with
preparedness
the
and career
prohibited source.
placement. TCC serves
This stands in
Southampton
stark
roads with
contrast
4
to the
campuses
findings of this
in
investigation
Chesapeake, Norfolk,
that have concluded that
Portsmouth,
Councilmember
and
Trayon
Virginia
White
Beach,
was
and
paid
6
to take
regional
official
centers.
actions
And
and
Senator,
did in
the
fact
staff, Madam
take
President,
official
asked me to make
actions
sure
as a
that I
result
let
of those
everyone know
payments.
that a TCC
Found
is
that
in Senator
Councilmember
Rouse's
White
district, and
agreed to
there's a
accept a
TCC
percentage
in Madam
of the
President's
contract value in
district.
exchange
So
for his
we all
assistance in
cover
procuring future
TCC.
contracts for the informant's companies.
TCC is the
This is
second
more akin
largest
to the second
of
ad hoc
23
committee, which investigated then
Virginia's
Councilmember
community
Jack Evans.
colleges, enrolling
In
over
that matter, the committee
24,000
found that
students.
Councilmember Jack
TCC's
Evans took
vision
action to
is
trade
be
his
the
council
community's
influence,
first choice
votes,
for
and prestige
education,
of office.
opportunity,
The
partnership,
findings of this
and
investigation are clear that
innovation.
Councilmember
The
Trayon White
college's mission is to
similarly traded
provide
on his council
collegiate
influence and
education
prestige
and
of
workforce
office,
training to
specifically his
individuals
chairmanship
of
over
all
and
ages,
oversight
helping
of
them
certain
achieve
district
their goals
agencies.
and contribute
Councilmember
to
Trayon White betrayed the
vitality
trust
the
of the
region
staff,
and
the
global
council,
community.
district
We are
agencies, and above all,
extremely proud
the
of
residents
our
of
alumni
Ward 8.
who prove,
Chairman, I will
and
now
prove, that from
ask,
here we can go anywhere.
you will ask, I guess,
Madam
whether or not there's an
President,
opening
please
statement
join me in
from
giving them a warm
Attorney
Senate
Frederick.
welcome.
Good afternoon.
I will in
Good
a second.
afternoon. President
Mr. McDuffie,
Constant,
you have submitted for the
thank
record.
you so very
the
much
record
for
of this
all that you
proceeding,
do in
the
helping
ad
to
hoc
shape
committee report,
TCC. And
including
I
the Latham and
join
Watkins
Senator
report,
from
complete
Norfolk
with its
in that
exhibits. Yes.
TCC and and
no
ODU are
objection, it's
also
accepted
both
in the
my
record.
alma maters. And
Mr. Cook,
there I was
do you
shaped
wish to give
at
an opening
TCC
statement?
and moved on, and
Yes, I do.
you are a breath of fresh
Please
air, and
proceed.
I attended
Thank you,
all of the campuses
Chairman
when I
Mendelson and
needed
council
my
members.
schoolwork.
I'd like
there you
to
are.
do what
Senators, let us
lawyers
give them the warm
oftentimes do
welcome
and
of the
to
Senate for
point
what
out
they
what
bring
I
to the
believe are the
lives
procedural
of Virginians.
defects and deficiencies in this proceeding to date, and why, as a consequence of those procedural deficiencies and defects,
Senator
this matter should be
Williams-Graves.
And finally,
dismissed
today we are
and
joined in the
put
gallery
on a proper
by members
track
of
as
Old
opposed
Dominion
to the track that it's
University's
been on
Blue
for
Crown
a
Society.
while.
They are
This
represented
council
in a
conducts
vacant
its
stand
business
by
pursuant to the Home
Chloe
Rule
Pope,
Act,
Dylan
to the DC
Hardnett,
Code, and
and
to the
Vegas
rules of
Federer,
organization
all
and
seniors
procedure
at
of the
ODU.
council.
The Blue Crown Society
For
is
each
a
council
prestigious
period, this
student-led
council enacts a different
organization
set of
dedicated to professional
procedural rules
development
and
and
organizational
leadership.
rules to
These
govern
students
its
are
conduct.
selected for embodying the
The council
values
initiated
of
this
Monarch
proceeding
Nation
pursuant
and are entrusted
to
with the responsibility
the rules of council period
representing the
25
university with pride
and to the council
and
25
professionalism.
period
The
25
society
rules.
fosters networking
Pursuant
and
to council
mentorship
period rule
opportunities
25,
while
rules
challenging students to
651 and
grow
652,
personally and
the council
contribute
established
meaningfully to the
the ad hoc
university's
committee
mission.
in the matter of
These
Councilmember
students spent
Trayon White,
today talking about
and
public
it
higher
adopted the
education,
proposed
issues that
resolution
were
which
important to
authorized a
them,
council
and
investigation of the
representing one of the
conduct of
Commonwealth's
Councilmember
great
White.
universities, Old
On
Dominion
December 16,
University.
as you
And I
have
can
noted,
personally say, Madam
the ad hoc
President, after
committee
spending some
met to
time with
consider
them-
the
with
investigative
them,
report that
our
was prepared by
future
your
is in
outside
good
counsel,
hands.
Latham Watkins.
Well,
And
that's
they,
wonderful.
you also,
Good
the ad
afternoon
hoc
to
committee
you.
also
Thank you for
considered
coming, and thank
sanction
you for
recommendations
visiting
and adopted
your
the ad hoc committee
senators.
report.
Hopefully, your senator, your
That
delegate,
meeting resulted
to
in
let
the
them
ad hoc
know
committee
the issues
adopting
that are important to you,
TR
especially as you're on your last
25-1000,
leg of
which
this part of
recommended
your
to
education
the council
anyway.
that Councilmember
And you see,
Trayon White
you get
Sr.
that
be
education,
expelled
how
from the
far
council
you can run.
pursuant to the rules of council
You have a
period
good
25
future ahead of you, and you're
and
part
council
of that
period
future.
25,
Senators, let us give them the
656
warm welcome
specifically.
of their Senate.
This hearing is conducted pursuant to that activity on the 16th of December. But it's important to note
Senator
that council
McDougal,
period 25 ended
Senator
on
from
December
Hanover.
31,
Thank you,
2024.
Madam President. Madam President, I rise for
Council
two
period 25
introductions.
Rule
senator has the floor.
Thank you, Madam
418A1
President.
provides
Madam
that a
President, we
measure
have,
that has
visiting
not
the
been
Capitol
finally
today,
adopted by the
a
council
number of
before
individuals
the
who
end
are
of the council
members
period
of
in which
ARC of
the
Virginia.
measure was
Madam
introduced
President,
lapses,
the ARC group is
without
here
prejudice to the
today
measure's
advocating
reintroduction
on
in a subsequent
Developmental
council period.
Disabilities Advocacy Day.
Council
And,
period
many
25,
of these groups are in your communities.
418A1
There are 23
requires that any
local
measure
chapters
that is
of
not finally
ARC
acted
around the
acted
Commonwealth.
on can
They live in
be,
your
but
communities,
must
and
be, in
they're
order to be
looking
acted on
for
further,
support in your
introduced
communities
into a
as well.
subsequent council
They
period.
advocate for individuals.
The reintroduction
and
of lapse
represent
measures happens
all
frequently
types
in
of
this council.
developmental
And
disabilities,
those
including
measures are
autism,
introduced
intellectual
typically with their
disabilities,
committee
Down
reports,
syndrome,
and the council is
and all
authorized to
other
move forward with them in a
developmental
subsequent council
disabilities.
period.
Madam President, if you could offer them the warm welcome
PR
of the Senate and thank them for spending
25-1000
their time
did
with
not
us
become
and
final on or
meeting
before
with our
December 31,
members in the legislature.
2024.
Good afternoon.
It therefore
Thank
lapsed.
you also for coming.
PR
23
25-1001
chapters. That
was
means
not
you
introduced
all
as
mean
required by
business.
Council Period Rule
You want to be heard, you want
25-418A1.
to be seen,
The
and
measure
that's why
therefore
so many
remains
people have
lapsed.
opened all these chapters.
At its organizational
You're making
meeting
sure
at the
that
beginning
you're
of
in
this
every
year, the
community,
council adopted
every
new
corner.
rules for Council Period
And
26,
really,
the current period we're in.
representation means something, doesn't it?
And
It
among the
means
rules that were
you will
introduced
not
and passed by the
be
council in
heard.
Council Period
So
28's
thank you for all
organizational,
that you do.
Council Period
Senators, let us give them the
26's
warm welcome
organizational
of their
me-
Senate.
meeting was Council Period Rule 26-418A4, which reads as follows. A sanctioned
Again,
resolution
Senator from Hanover.
introduced
Thank you, Madam
pursuant
President.
to
Madam
the, to
President, I
Rule
have one
652
additional,
that is
introduction.
pending
senator
at the
may
end
say
of a
on.
council
Madam
period
President, in the
shall be in
gallery,
the
we have
same
some
status that the
individuals
resolution was
from
in at the
Hanover
end of the
from
prior
our school
council period
system.
and
Madam-
assigned a new number. If notice required by these rules has been given in the prior council period, no additional notice shall be required before action on the matter. It appears to me that Council Period Rule 26-418A4 was created to address the failure of the council to reintroduce PR 25-1000 as required by Council Period 25 Rule 418A. Logically and legally, that attempt does not accomplish the reintroduction of PR 25-1000. The rules of the council very clearly apply to matters undertaken by the council in each of the relevant council periods. The rules of each council period provide that measures undertaken during that council period have to be reintroduced, otherwise they lapse. However, that has to be done consistent with the council rules and council custom and practice. The defect, in my view, in Council Period Rule 26-418A is that it cannot apply to PR 25-1000 that was introduced and not finalized during Council Period 25 because that resolution lapsed on December 31, 2024 and has not been reintroduced. Until that resolution is reintroduced pursuant to the rules of Council Period 25 in which it was created, not the rules of Council Period 26, this council has no authority to take any action with respect to PR 25-1000 because it has lapsed as a measure. Council Period 26 rules cannot provide a legal or logical basis to affect a measure that was introduced in a previous council and has lapsed. Council Period 26, Rule 418A4, certainly can affect council measures going forward, but it cannot reach back and revive a lapsed measure, which is what the rule purports to do, in my view. So I believe that that defect leaves the council with the obligation to reintroduce PR 25-1000 if it chooses to, but it cannot act on it by virtue of a rule that was introduced in a subsequent council period to revive a lapsed resolution from a previous council period. Further, I believe that this expulsion process violates both the Home Rule Act and the Board of Ethics and Government Accountability Establishment and Comprehensive Ethics Reform Amendment of 2011. Prior to 2013, the Home Rule Act did not include a provision for the expulsion of a council member. Legislation that would reform our ethics rules, and some of you, probably only council member, the Chairman Mendelson, who was on the council at that time, remembers the very difficult situations or circumstances the city found itself in with respect to its elected officials. And I think the council appropriately took legislative action to address the public's lack of confidence in some of the activities of elected officials. But when it enacted that legislation, in addition to creating BEGA and an ethics regime, it also included, for consideration by the citizenry, an amendment to the Home Rule Act. And those amendments to the Home Rule Act were to, among other, principally, to provide a term, and it authorized for the first time the council to expel a member of the council. That power did not exist before 2013, when that amendment to the Home Rule Act took effect. The BEGA portion of the legislation, however, took effect in 2012. Now, it's important from my perspective to note that the BEGA legislation created BEGA as the exclusive entity to enforce violations of the Code of Conduct by members of this council, the mayor, and other government employees. The Board of Elections, Board of Ethics and Government Accountability was the exclusive authority to enforce violations. The committee report for clearly that most importantly, the bill 19-511, as the bill was known at that time, most importantly, the bill will establish a new entity charged exclusively with administering and enforcing the new and enhanced laws and code of conduct. The committee report goes further on to say the committee finds that violations of the code of conduct that should be penal in nature warrant further study by the Ethics Board, BEGA. Thus, violations that substantially threaten the public trust would be determined by recommendations of the new board, BEGA, to be followed by an act of law adopted by this council following those recommendations. As I've noted before, the ethics laws apply to council members and all other government employees. DC Code 1-1162.02 establishes BEGA, whose purpose shall be to administer and enforce the Code of Official Conduct and to receive, investigate, and adjudicate alleged violations of the Code of Official Conduct. Nowhere in the DC Code is the council given any authority whatsoever to administer, enforce, investigate, or adjudicate violations of the Code of Conduct. DC Code Section 1-1162.02A establishes within BEGA the Office of Government Ethics, OGE. DC Code Section 1-1162.12 provides that the director of OGE shall conduct a preliminary investigation of a possible violation of the Code of Conduct or ethics rules that is brought to the attention of OGE or to BEGA through a number of different vehicles. If during or after a preliminary investigation, OGE has reason to believe that a violation of the Code of Conduct or ethics rules have occurred, the director shall present evidence of the violation to BEGA investigation and the issuance of a subpoena if it finds reason to believe a violation has occurred. I would point out that nowhere in the DC Code is the council given any authority whatsoever to conduct a preliminary investigation or to authorize a formal investigation of alleged violations of the DC Code of Official Conduct. Now, it is my understanding, although not public, that BEGA has begun a preliminary investigation into the alleged conduct of Councilmember Trayon White. And that investigation, to my understanding, is ongoing. DC Code Section 1-1162.13 provides that OGE shall initiate a formal investigation to investigate these possible violations by a member of the council or whomever. Adversarial, and the director of OGE shall present evidence of the violation. Nowhere in the code, in the DC Code, is the council given any similar authority to conduct a hearing at which evidence of alleged violations of the DC Code of Official Conduct or ethics rules are adjudicated. DC Code Section 1-162.15 provides that following the hearing before BEGA, BEGA may levy a penalty in accordance with the DC Code or refer the matter to the prosecutorial authority. Nowhere in the DC Code is the council given any similar authority to levy a penalty for violations of the DC Code of Conduct in the DC Code or to refer such allegations for prosecution. DC Code Section 1-1162.17 provides that appeals of any order or penalty made by BEGA shall be made to the Superior Court of the District of Columbia. Now, this is important for a couple of reasons from my perspective. The council has, in my view, and in violation of the relevant DC Code provisions, unlawfully usurped the legislatively mandated jurisdiction of BEGA to adjudicate alleged violations of DC Code of Official Conduct and ethics rules by Councilmember Trayon White. It has denied Councilmember White the statutorily mandated right to have the alleged violations of the Code of Official Conduct against him that have been made against him adjudicated by BEGA, and in so doing has denied, again without legal authority, Councilmember Trayon White's statutorily mandated right to appeal an adverse decision of BEGA to the Superior Court or to the DC Court of Appeals. It is also interesting to me to point out, I think, that Council Period 25 Rule 653A4 states that the accused, in this case Councilmember Trayon White, shall have no rights beyond those stated herein, and the accused shall not be entitled to any process beyond notice and an opportunity to be heard. Now, the thing about that that's troublesome to me as a member of the bar for a very long time is how does the council, by a rule, not an amendment to the charter, not by a DC Code provision, deny a citizen a right to appeal to the court system an action that they feel aggrieved about? The council cannot, by rule, effectively amend the charter by circumscribing the jurisdiction of the DC Superior Court or the DC courts and saying you can't go to court to complain about what we've done. If the council decided to have this hearing in a dark closet and have no record of it and no appeal of it, how is that fair? By simply rule fiat, we just decided, well, we're not going to give you a hearing. We're not going to let you appeal to the court. You get what you get. That's extremely troublesome to me, and I think the council needs to look at that. I understand this is a very unusual procedure, and nobody wants to be involved in this kind of council member. You get zapped by us, and you can't complain to the court. That's not going to work. I don't believe any court in the District of Columbia will likely accept the fact that the council has put itself beyond review of the courts, but we'll see. The council has ignored, and Councilmember McDuffie did refer to previous council disciplinary proceedings, both of which, unfortunately, I was involved in. The inexplicable disparate treatment of Councilmember White's situation is, again, problematic to me. In 2013, as Councilmember McDuffie pointed out, the council censured then Councilmember Berry for DC Code of Official Conduct and Ethics violations. And as Mr. McDuffie indicated, Mr. Berry reported those ethics violations. He admitted his mistake. He repaid the money, and he paid a fine. And there was a BEGA process. There was a BEGA process that was used as the basis, some of the basis, I won't say exclusively, some of the basis for the council to censure him. And you're absolutely correct. The council did not find that there was substantial evidence that warranted expulsion, but the council did find there was substantial evidence to merit censure of then Councilmember Berry. But it was based on, in part at least, the fact-finding record established by BEGA in its investigation. In 2019, as Councilmember McDuffie correctly noted, the council enacted or passed a resolution recommending the expulsion of Councilmember Evans. And in that case, very similarly, there was a BEGA investigation. There was a negotiated settlement by then Councilmember Evans with BEGA. There was a fact-finding record by BEGA that this body decided was substantial evidence that would warrant the expulsion or recommendation for the expulsion of Councilmember Evans. And that went forward. Councilmember Evans resigned before that resolution could be voted on. But what I would draw the distinction differently than Councilmember McDuffie did in his presentation is that the focal point is not that what the council did, it's how the council did it. In both cases, those cases of council member discipline, and fortunately there are only two, those decisions were based on the fact-finding record by the entity in this government that is responsible for finding those facts, not by the council sitting as both judge and jury. Because in net effect, what you've done here is that you have decided that you are going to be the fact-finder through your agent, Latham and Watkins, and you're going to say, we found those facts, and then go back and say those facts constitute substantial evidence. That's sort of inconsistent in my view. The substantial evidence standard that is in the Home Rule Act and is recited in the council rules is not a de novo review sort of assessment. It is an appellate review. It is a decision of an appellate body that the fact-finding body has produced in its record substantial evidence that would support the result that the fact-finder found and or recommended. This government does it all the time with the Office of Employee Appeals, formerly, and now the Office of Administrative Hearings. And the Superior Court and the DC Court of Appeals review the record of the fact-finder and determine if the fact-finder has adduced substantial evidence to support the recommendation. But in none of those cases is the finder of substantial evidence the fact-finder. And what the council has constructed, which I think is not what the Home Rule Act requires or says, mandates, it has said, we're going to find facts, and then we're going to look back and say those facts are substantial. That's not correct. That's not the correct application of the substantial evidence rule. In the report, your lawyers cite a number of cases to support this idea that substantial evidence is what it is. But it's important to note that in each and every one of those cases, the DC Court of Appeals decision cited is citing and affirming a finding of the Superior Court judge who said there was substantial evidence based on the fact-finding record of an administrative agency. In each and every one of those cases, the fact-finding agencies found that there was evidence to suspend the person, not to terminate them, the functional equivalent of expulsion. Thank you. So again, my point is that there are cases cited and lawyers do it all the time, I get it, that don't really, when you look at the facts of them, don't support the conclusion that is reached. In the MPD cases cited in the report, those police officers who were indicted, those police officers were suspended pending a fact-finding hearing on their guilt or innocence on the charges of the indictment. They were not terminated. They were not expelled from the police department. So those cases aren't really opposite to this situation, because what you're doing here is expelling, is terminating, based on an indictment where my client has said in court, as everybody knows, that he's not guilty. So how do you balance an affidavit or indictment that says you did it against his constitutionally guaranteed right to a presumption of not guilty unless and until it's proved beyond a reasonable doubt in trial? Now, there is no, to my research, and I'm absolutely willing to be wrong. I've been doing this a long time, and sometimes I am not correct. But to my understanding from my research, there is no state in the United States that allows the expulsion of a member of the state legislature simply upon being indicted. All of them require a conviction. Now, you can get suspended, you can be put, in a different posture, but you're not expelled. In the Congress of the United States, you are not expelled unless and until you're convicted. Senator Menendez is the most recent example of that. Now, Senator Menendez resigned rather than be expelled, but you can't be expelled based on an indictment because, again, I hate to personalize it, I've represented people who were indicted who somehow were found not guilty. Prosecutors are not always right. And I was a prosecutor. And I prosecuted Councilman Mendelson. And I was not right. He walked away unscathed. So just because you get charged, you don't get convicted. So I think that this process that we are involved in is problematic from a procedural point of view. I believe that the council does not have this resolution from the previous council period properly before it. And it needs to be brought before it properly before it can do anything with it. But I think in a more procedurally substantive sort of way, I think the council's construct, the council's design of a process is inconsistent with prior council behavior with respect to similar council member discipline, and for no good reason. Because Bega is conducting an investigation, to the best of my knowledge. Bega can conduct an investigation. But Bega then, a separate entity, can have its fact-finding record reviewed by the council and determine what, if anything, the council wants to do. But it doesn't make sense to me for the council to be both the fact-finder and the review authority. So, I've gone on a lot, and I don't know if there are any questions, but I'm happy to answer them. But I believe this process is defective. I believe the council needs to go back and get it right. And I believe that for that reason, the council should not go forward today or certainly on the 4th of February with action on the resolution recommending expulsion of Councilmember Trayon White, Sr. But after that, I'll stop there, and if I have any questions, I'm happy to answer.
Thank you, Mr. Cook, for your statement and your reference to my personal conduct as well. I do want to note, I'm not sure every member is here at the moment. I think so, but every member has been here. I do want to note that for the record. Let me ask Mr. McDuffie if he has any questions.
I do, and thank you, Chairman. Thank you, Council. I appreciate the testimony, the remarks, the statement. I do think it's wrong in a very important respect. As you acknowledge that you are occasionally wrong. I think in this instance, when it comes to Thank you, Chairman. As I was saying, and as you acknowledge, you are occasionally wrong, Mr. Cook. I know you are a well-seasoned lawyer. And I think on a very important point relevant to this proceeding, you are wrong. I think that the Home Rule Charter, I don't think, like it expressly written in the Home Rule Charter, the authority for the council through rule to create procedures for expulsion. And what we have done heretofore have followed that authorization granted to the, and we have done so through the rules that we have adopted. I do have, just if I could really briefly, Mr. Chairman, a couple of questions for Mr. Cook. Mr. Cook, you agree that the ad hoc committee extended 3 separate invitations for your client, Councilmember Trayon White, to address the committee and dispute any or all of the investigative findings, and that he declined each of those 3 opportunities to meet with the ad hoc committee, yes or no?
That is correct. Mr. White relied upon his constitutional right not to make any statements that might incriminate himself, so he, upon advice of counsel, chose not to engage in an interview or requested interview with the council's representative.
Thank you.
That is correct. But I will also add...
So 3, you answered the question, Mr. Cook,
Okay.
I appreciate it.
No,
So 3 opportunities Mr. White had during that ad hoc committee process to speak directly or question the investigative findings and the violations of law. Apparent for the folks who are here, but maybe there's some folks at home watching. But Councilmember Trayon White is present today, and he's seated to the right of his counsel, for the record. He's in the council chambers today. Mr. Cook, it is a fact that he has declined once again, and for the 4th time, an invitation to testify and to directly respond to the findings of this investigation by the ad hoc committee, and instead has delegated to you, his attorney and representative, to speak on his behalf.
Mr. McDuffie, I am wrong sometimes as a practitioner, but one of the things I'm not going to be wrong about is what I'm about to say. It is absolutely inappropriate in any court and in any proceeding that I've ever been involved in.
A simple yes or no does it.
To comment on the individual's, the accused, the subject, relying upon his constitutional right not to say anything. That is fundamentally incorrect, because then you draw a negative inference by not speaking when he has no obligation to speak.
You're right, Mr. Cook. He has zero obligation.
And so
Mr.
you
Cook,
don't draw a
Mr.
negative
Cook, I'm asking questions. You can
inference
answer
in
the
a
questions
proceeding like this.
that I'm asking, but now's not the time to be lectured to. I'm asking the question about.
No, sir,
the
I'm not
fact.
lecturing. I'm making an argument on behalf of my client. I'm answering on behalf of my
But
client.
you're not in the court of law, and I'm not asking you to argue.
You're
I'm simply
absolutely
asking
right.
you to answer a question, yes or no.
I am absolutely cognizant of the fact I'm not in the court of law.
Okay, all right.
I'm not trying to make that argument. But I will say I'm not going to answer that question, and I'm going to instruct my client not to answer that question.
Got it.
But we're not, that I just think is inappropriate.
Okay. So, to be clear, so that the public can understand where things are, this kind of, I think it goes without saying, but I think it is important to be clear, right? You're a seasoned lawyer. I'm not sure what that was, Chairman. It's on Zoom.
I think everyone's muted as far as I can tell.
So again, just to be clear, I know this seems like very basic questions to you, Mr. Cook, but I think it's important to ask these questions. Were you in the vehicle with Councilmember White and the confidential informant on June 26, 2004? 2024?
I decline to answer on the grounds that the answer might tend to incriminate me.
Okay. So you may or may not have been in that vehicle?
I decline to answer on the grounds that the answer might tend to incriminate me.
Okay. So it's no, I appreciate that. And I think it's important to give you another opportunity to say whether you were present during any of the conversations that Councilmember Trayon White had with the relevant Department of Youth and Rehabilitative Services and/or Office of Neighborhood Safety and Engagement officials relevant to the investigation conducted by the ad hoc committee or the subject of the indictment. Were you there?
I decline to answer on the grounds that the answer might tend to incriminate me.
All right. And so it's fair to say, as Councilmember White's legal representative, that you do not have any direct knowledge of the events surrounding his interactions with the confidential informant?
It's a bifurcated question, but I would decline to answer on the grounds that the answer might tend to incriminate me and on the basis of attorney-client privilege.
So you weren't there, is the implication?
No, I said I decline to answer on the grounds that the answer might tend to incriminate me and on the attorney-client privilege.
But because, Mr. Chairman and colleagues, our rules for this proceeding don't allow testimony from witnesses having direct knowledge or willing to share that direct knowledge or facts of the circumstances relative to the specific charges under consideration, while I appreciate Mr. Cook's statement and his legalese, I don't have any further questions for him at this time.
Okay, thank you, thank you. I would like to add, if I might.
I think, Mr. Chairman, I'll turn to you. I think you have an opportunity.
I'll let you add whatever you want to add, maybe. Depends on how long you go.
No, it's not real long. I just think that in response to one of the statements made by Mr. McDuffie, I think, well, I don't want to be argumentative for argumentative's sake. I just disagree that the argument that I made about the process, the Home Rule Act certainly gives the council the power, the authority to issue rules and regulations to implement that amendment to the Home Rule Act that provides for the expulsion of a council member. But just because the council has the authority to issue a rule or regulation doesn't make any rule or regulation that it issues per force proper. The council has been told by courts a number of times over the history of the government of the District of Columbia that legislation that is enacted, rules that it is enacted, did not meet constitutional muster in one way or another. And that's fine. But to say that because we have the authority to issue a rule, any rule we issue must be okay is not correct in my view. That's the thing I don't think I was wrong about.
That's also not what I said. Under the Home Rule Charter, to make rules that outline the expulsion process.
Right.
That we're following those.
And my disagreement, and I'm sorry to go back and forth, but my disagreement was that the rule that says, I quote it, that says the accused shall have no rights beyond those stated herein, and the accused shall not be entitled to any process beyond notice and an opportunity to be heard, violates the Home Rule Act because it denies the Superior Court jurisdiction to present a grievance to the court. That's the Rule Act.
And I appreciate you clarifying that. I think the record reflects your clarification.
Okay, yeah.
So let me clarify at this point. Mr. McDuffie, as chair of the ad hoc committee, you have further questions or statements?
I may have a closing statement depending on whether or not Mr. Cook has anything further he'd like to put on the record.
So let me turn to Mr. Cook. I think I may have asked this earlier, you don't have any witnesses.
There are no witnesses, Mr. Chairman.
Our rules, which we think are fine, allow for opening and closing statement by you. Do you have a closing statement?
I believe what I've said could serve as both an opening and a closing statement.
Okay,
So I have no further closing statement at this point.
okay. Mr. McDuffie?
Just briefly, Mr. Chairman, I think it bears repeating that, and I stated this more than once, the findings of this investigation by the ad hoc committee, I think, are clear, that Councilmember Trayon White Sr. violated DC law, violated the code of conduct, council rules, and committed a violation of law that amounts to a gross failure to meet the highest standards of personal and professional conduct.
Thank you, Mr. McDuffie. So I'm going to conclude this proceeding, but I'm going to note a couple of things, actually maybe 3 or 4. First of all, there is precedent year after year after year, or maybe I should say council period after council period after council period, where we have held over resolutions. And the resolution that will be that I intend to put before the council on February 4th is PR 26-14. And it was accepted in the log of introductions and referrals that was approved by the council on January 7th. And on that log, we also held over PR 25-987, PR 25-995, PR 25-1023, PR 25-1044, PR 25-1083, and PR 25-1102. I don't know if that's the complete list, but it has been our practice and precedent for many, many council periods. I remember going back to Councilmember Chair David Clark with holding over the comprehensive plan, a bill that was held over from one council period to another. And as I said, this was on the log adopted by the council on January 7th. I will also note the council has always had the authority to discipline its members, and that the violations that I outlined at the beginning, both of 2 statutes, but also of the council's code of conduct, not the District of Columbia code of conduct, but the council's code of conduct. The Home Rule Act does say, I believe it's Section 401E, that gives us the authority to expel. That was not original to the 1974 Home Rule Act, as I understand it, but it gives us that authority to expel. But it also, at the same time, says that we can only do so by a 5/6 vote. That's an extraordinarily high requirement for a vote. And I will add as well, I guess 2 points. One is that, it's always a bit dicey to look at what the process is or the requirements are on the executive side, because we are the legislative branch, and the legislative branch has to be independent of the executive branch, as opposed to having to answer to requirements or edicts or whatever one wants to term it of the executive. And the other point I want to make is that we have to be mindful that those of us who are on the council, those of us who are elected, the legislative branch has to be sensitive to what the public will accept or tolerate with regard to ethical behavior by the council. And I'm speaking very broadly right now, very broadly. But the issue here, and unfortunately I've been on the council long enough that I've seen this in 2019, and I saw it in 2014, and I believe it was in 2011. I've seen it too many times. They have to have trust in the government. They have to have trust in the legislature. They have to have trust in those who are elected. And being asked to wait possibly 2 years is more than is in the public interest. The last point I want to make is that we've tried to be very mindful of due process. So the issues that underlie this proceeding today came to light on or about August 18th by memo that was dated, I think at the end of that week, maybe August 20th. I notified all the council members, including Trayon White, that I was setting up an ad hoc committee. The ad hoc committee had 90 days. Councilmember McDuffie, Chair of the Ad hoc Committee, noted that in the interest of due process, that the council member was invited to be interviewed several times. I totally get the discrimination in Fifth Amendment, but from the standpoint of due process, I think the point there is that the Ad hoc Committee 4 times or 3 times offered an opportunity. The council's action, the ad hoc committee's action on December 16th was at a public meeting. It was followed by a memo to me, to Councilmember White, on December 17th, again notifying him, outlining, and trying to ensure that there's due process, and then today's proceeding, where there's an opportunity, as I characterized it in my December 17th memo, the opportunity to respond to the recommendations of the ad hoc committee and present your case and counter the recommendations. So I think that we've been mindful of due process. That's my point there. There is, let's see, there's been an opening opportunity for a closing statement by you, Mr. Crystal. So with that, I'm going to conclude this proceeding. I want to thank everyone for their participation. The time is 1:20 p.m. and this proceeding is adjourned.